Okay, well, I think we can go ahead and get started. Thanks again, everybody, for coming to our webinar today, Supported Decision Making and Other Alternatives to Guardianship. My name is Mark. I'm the Communications and Community Engagement Manager for RIPIN. And RIPIN, if you're not familiar with us, we're an organization that helps individuals and families of all ages throughout Rhode Island access and navigate health insurance systems, healthcare systems, education and special education systems, and other supports. I'm joined today by our presenters, Kevin Nerney from the Rhode Island Developmental Disabilities Council, and Ann Mulready from Disability Rights Rhode Island.
Yes.
And they are going to talk about our topic today. Throughout the presentation, at any point, you can click on the Q&A button on your screen and type in any questions that you have. We're going to hold those mostly for the end, but feel free to send those questions in as they come to you, and our presenters will do our best to answer them at the end. I think without further ado then, I can turn it over to Ann and Kevin.
Great, thank you very much, and please bear with us as we walk through our slides. As Mark mentioned, we're here to talk about supported decision-making and other alternatives to guardianship. Supported decision-making is a new alternative in Rhode Island, but we're going to walk you through sort of guardianship in general and alternatives to guardianship, and then address supported decision-making. So, and
you might have to bear with us a little bit. This is the first time we've tried.
I have some technical difficulties here. I don't know if Mark can help me on screen share. Oh, here we go. So in terms of our presentation, this is general information about the law and legal practice. So that's what Kevin and I will be presenting. It's not specific legal advice to any individual here. And so you shouldn't really rely on this presentation as information specific to you and your situation. Even though I'm an attorney and Kevin is as well, this is a presentation about legal information, not advice.
So a couple of definitions to kind of start off with. We're going to talk a lot about capacity or competency, and we'll dive a little bit more into that later, but capacity is the legal ability to perform an act. And so there's different levels of capacity that are required to make different decisions or to perform different acts. For instance, you might have to be over 18 years old to enter into certain contracts. You wouldn't have the legal capacity to do that if you were under 18. You might need specific kind of citizenship to vote in certain elections. Those are kind of the legal capacities. We'll talk a little bit later, but when we're talking about making decisions about healthcare, some decisions are very specific about a very invasive procedures, and some are more general about who would I want to be with me to help make those decisions. And so there's different kinds of legal capacity for different decisions. The next definition is a guardian. The guardian is the person with the legal authority to make decisions for another person, the ward. And this is really important. The ward is a person who's put under protection of the state. A lot of people think, I'll get guardianship and then it's done. I'm now the guardian of this person, I can make their decisions. That's not how it works. The person is actually a ward of the state. So the state is ultimately the one that has to oversee that, and any guardian will have to report back to the state or the court that gave the guardianship. Some kind of interesting evolution of standards. I think a lot of people have heard the best interest of, right? We often hear about it in family court when it comes to kids. What's in the best interest of the child? When we talk about guardianship of adults, though, the best interest standard is when you replace what the ward would want with what the guardian thinks should happen. And we've moved away from that standard, and we've moved to what we think is a slightly better standard, which is substituted judgment. And that's where you replace the ward's decision with what the guardian believes the ward would want. So you take as much information as you can, you do your best to understand what decision the ward would want, and then you utilize that to make that decision. So the next is probate court in Rhode Island. And how many probate courts are in Rhode Island? Is it 30?
I want to say 36, but
I believe it's 36.
Every city and town has one. Yes.
Right. So this is where all these decisions happen. It's a municipal court, so it's in your city or town. They often usually take place in a town hall setting. So it's kind of an open area where multiple people will be there for these probate court judges to hear the cases. And then competent. So we have these legal capacity to make decision, which we talked about before, but what is competency and what should we think about competency? And there's a statute in Rhode Island specifically talking about people with developmental disabilities. And I wanted to use that definition here because I think it will help form what we're going to be talking about for the rest of this. Competency means the ability to understand risks and benefits when the information is presented to you, to the person, in a way that the person will be able to understand it. So it's not just, here's a pamphlet, read it and make a decision. It's really trying to get the information to the person in a way that they can understand it and then have them make that decision. And that's what competency is. So you can have a supported competency, and that's where we get to supported decision-making a little bit later in the presentation.
Okay. Excuse me for a minute. So I'll just jump in here and talk a little bit about Rhode Island guardianship law. Most of guardianship law is covered by state statute. And in Rhode Island, we have a really good philosophy behind our guardianship law. And that's found in the intent section of the statute. And that part says that finding and adjudicating a person to be incapacitated and in need of a guardian deprives that person of all of his civil and legal rights. And therefore, the state's intent is to set up a system that permits incapacitated persons to participate as fully as possible in all decisions impacting them. And the courts are supposed to do that in a way where they look at each case and provide the form of assistance to the ward that least interferes with the legal capacity of that person to act in his or her own behalf. And courts are supposed to liberally construe that intent provision to accomplish its purposes. So we start off with a very broad and intent statute that's very mindful of courts inserting the least amount, intruding in the least restrictive manner possible into a person's life. That sometimes is very different than the reality of the outcome of these proceedings. I'll let you go, Kevin.
Sure. So yeah, I think that's a great way to frame this, is that the statute is really, really well written and really attempts to ensure that guardianship isn't handed out unless it's absolutely necessary. And even then, it's as limited as possible. As Ann said, though, that's not always the reality of it. Further, with the statute, the guardianship law sits in Rhode Island General Laws 33-15. So when you file for guardianship, the first thing you have to file is a petition to the probate court. And there's a form there. You can request guardianship in 1 to 4 of 4 areas. That's financial, healthcare, residential, and relationship. Once you file that petition in those areas, you have to include at least one, what they call decision-making assessment tool. And that should be filled out by a physician. You can file more than one. Oftentimes people do, but at least one of those should be filled out by a physician that knows the person. After guardianship is granted, if it is granted, there is a way to modify it or to remove the guardianship entirely. But as we're going to talk a little bit, that gets more difficult than one would think. You essentially ask the judge to say, yes, this is necessary. So it's then hard to go back and say, wait, it's not necessary anymore. So some of the processes and pitfalls. We talked about probate court and how there's 36 of them in the state. So you can imagine that it's not always consistent from one court to the other, from one judge to another judge. Some judges might really understand the statute and the intent and liberally construe that statute the way it's supposed to. Others might be a little bit more apt to grant guardianships. And so you're never quite sure what you're going to get. The other thing about probate court is it is public. So unless a petition and everything else is sealed by the judge, which some do automatic and some don't, it's completely open to the public, including, remember we talked about the DMAT, the decision-making assessment tool, that's filled out by a physician. So there's medical information about an individual now made public in the probate court. The petition itself is, there's plenty within the petition that needs to be filled out. One of the requirements of the petition is that you have attempted alternatives prior to filing for guardianship. So that's a requirement anyway. Again, as Ann pointed out, that doesn't mean people always do it, but it is a requirement of the petition itself. Some of the other issues fall around the DMAT. Again, it should be at least one filled out by a physician, but how well does that physician really know the person they're talking about? So, you know, if the physician is just someone you go to for your annual checkup, you know, should that person be saying you don't make good decisions about finances? I don't know. I don't know the answer to that, but it seems to me that oftentimes the people filling these out have a very clinical mindset instead of kind of a whole person mindset, and so they might be more apt to say that a person needs guardianship, even when they don't. And privacy, I guess I kind of already went over the privacy piece of it here, but right. The probate courts are obviously a public body, and like I said, you're in a town hall. Most people have been in their town hall. It's an open space. There's often people sitting there waiting for their turn to go. They can hear the arguments and what people are saying. I personally had one case where the other attorney and the judge started talking about the person's IQ in front of the person loudly, and there were other people in the courtroom. And so you can imagine that kind of violates what I think most of us would consider important privacy issues.
And that can vary from court to court. There are a few courts who will seal DMATs, and if you ask them, will give you some protections within the courtroom if you have sensitive information, but that's not always granted and not always in every courtroom. So as Kevin says, there is a loss of privacy around personal information.
So beyond the process and pitfalls, there are other costs as well. Obviously, there's monetary costs. Generally, hiring attorneys is not inexpensive. We do have to charge money to make a living, and that's what other attorneys do as well. So there's lawyers' fees. There's often filing fees. The judge almost certainly will appoint what they call a guardian ad litem, which is a person that can go out and interview people and then bring information back to the judge. Oftentimes that person is an attorney as well and makes attorney's fees while they're doing that. Potentially there's a bond that would have to be paid. And then again, this isn't a one-time thing. You're probably going to have to go to court multiple times to get the guardianship, and then you're going to have an annual accounting and status update every year. And you're going to need to probably, depending on how big the estate is, how much control a person has, you might need an accounting done every year. Or you'll certainly have to provide the accounting, but you might have an expert come in, and that's an additional cost as well. But beyond the monetary costs, and this is something I know, Ann, we've spoken about this a lot, there's a lot of non-monetary costs as well. And that's in addition to just removing somebody's civil liberties, which we consider a pretty big cost to begin with. But the time that goes into it can be fairly extensive. We often see disagreement among family, and that usually happens in two ways. The first and probably the most common, is we see parents who are divorcing or are divorced using this process to kind of further the divorce that they already went through or are currently going. So they're fighting over a child, and it's more about the disagreement between the parents than the actual guardianship themselves. The other is we often see parents, and I think all parents, right, have their primary issue for their children is often their safety. So their focus is safety. And usually when people are attempting to get guardianship, it's out of a good place where they want to make sure that their children are safe. So the other disagreement we often see in families is parents want the guardianship and siblings, oftentimes the person as well, and their siblings do not want the guardianship. They say, no, why are you trying to take away, my siblings' rights? We've grown up with them. We can see how well they can function and live in the community. And again, now there's a court involved in a family relationship. So what was often a parent-child relationship, is now a parent having to report to a court about the relationship and about monetary status and about other statuses of that child. So you've invited the state into a family relationship.
And as Kevin has said, I mean, this pursuing guardianship can promote disagreement among family. I mean, it is an adversarial process. And so things tend to get more adversarial, not less adversarial through this procedure. And that can act to the detriment of the person that people are seeking guardianship of, the ward, who is often finds themselves caught in the middle of a family argument. And with it can be an extremely stressful experience for them. So this is hopefully where we can stop and use our chat feature, but we're always interested in hearing from you all your thoughts about why guardianship might be necessary. And we have some questions.
Yeah, and I can share some of some comments that come in as well. One individual writes that they have a family, this is probably an educator or a school professional, they have a family who is trying to gain guardianship to control the choices of one of their students. But this person says that this student is capable of making choices independently with limited supports, 20-year-old student. Another individual asks, I'm currently the legal guardian of my adult daughter who has autism. And what if I were to pass away in the unpleasant event of my death? What happens with the guardianship?
So why don't we start with the first one about, it sounds like probably an educator, right, has a student whose family is attempting to get guardianship over, but they don't believe that that the person requires guardianship. There's a couple different ways outside of the legal process. I don't know if the legal process has started yet. You can talk to the individual, say, is this something that you want? And if the answer is no, they can contact their own attorney. They might be able, I don't know if I don't want to speak for Disability Rights Rhode Island. I don't think you guys are taking these cases anymore.
Not very many of them, no.
But potentially you could reach out to the Bar Association to get a pro bono attorney, especially if it's a child that couldn't afford it. They might be able to offer somebody to help defend. If it is in the process, the person could probably fill out their own DMAT. They could send in a petition to the court as well, if it's already in that process, just kind of stating their own opinion, someone that knows the person well. Other ideas, Anne?
Yeah, I mean, I think if you're not at the stage of filing yet, then there certainly are alternatives that we're going to start talking about that somebody could use. And that may be something to introduce. They certainly give a certain amount of assistance to people and support so that there isn't this sense that somebody's left on their own to deal with processing the risks and benefits of a decision, but they will have support. And we also, the DD Council in our office, think supported decision-making is a great answer for many individuals. So we'll talk about that in a bit too, which really is a mechanism of providing needed support, but enabling someone's preferences and decisions to carry the day. So you know, I think especially for a transition age youth, there's a lot of people still around them that can help support those kinds of conversations about other ways to do things, alternatives to guardianship. Other questions we should,
I mean, getting to your question, why get guardianship, why seek it? We've had a few folks respond. One, I'm looking to get guardianship of my brother. Our father's passed away. He's on the spectrum. He's nonverbal. Another, I have a patient who is 23 years old with developmental disabilities, and the psychiatrist will not prescribe needed medications because they say, the psychiatrist says she, quote, does not have capacity to make that decision. Another comment, another individual kind of recounts their story of going through the process and how it was not adversarial or confrontational. It was a bit tedious, but going, you know, from the point of view of protecting my adult child, and you know, this commenter understands that not everyone's coming from the same place. It's not always that way, but it sounds like they generally had a pretty positive experience.
so I think we can answer some of those questions that came up as we go along, and cover some of the questions about medical decision making and other decision making.
So some of, there's a lot of different reasons people give to why they want guardianship. It usually comes to safety, right? We want to protect somebody that we love. And so what we want to do is say, well, you know, what is it that you want to protect them from? And let's see if we can find an alternative to getting guardianship that might work better, be less expensive, allow the individual to retain, you know, full citizenship. So just as a general alternative, a lot of parents just want to know what's going on. It's not so much that they want to have decision-making control, but they want to be informed. Say you're you have somebody who's still in school, but is 18 or 19 years old, is now legal and adult. You know, say somebody goes to a hospital, again, as an adult, you just want to be aware. So you can get releases of information, and they can be specific in any of the areas around healthcare. Oftentimes hospitals or doctors have their own, what they call a HIPAA waiver, so that they can contact you and give you information about your adult child. It could be financial or it could be educational. I think a lot of schools now also have a FERPA waiver form for when a child with, say, an IEP turns 18. Now they're an adult, they're going to be the ones making those decisions, but almost every child wants their parent to go with them still. It's very, very rare that a child is so confident with their IEP that they think they can handle that meeting by themselves. So they, in almost every case, the now adult child has signed off and given permission for the school district to communicate with the parent and for the parent to, you know, continue to attend IEP meetings. The next level is a power of attorney. And again, that can be very broad or very narrow. That gives the ability of somebody to act on somebody's behalf. So you could be, again, in finance, you could say, I want to open up a bank account. I give my parent the authority to open up the bank account and then to, you know, handle the bank account for me. It could have to do with healthcare. There's actually in Rhode Island a statutory healthcare power of attorney. It can be very broad. It can be very narrow. It can be very similar to the powers of a guardian, frankly, if it's written a certain way. But it certainly is less restrictive, and you know, it really does allow for a person to continue to have a say in their own life. In Rhode Island, there's also a statute for people with developmental disabilities, people who receive services from the State Division for Developmental Disabilities. There's two things there. There's one statute that allows for an advocate, and there's one that allows for a parental successor. Currently, my understanding is the Division for Developmental Disabilities will do mailings to parents, and will communicate with parents, even of obviously adult children. So this would allow, for instance, if you named a parent successor, DD may continue to communicate with them about the person after their death, which is, again, that's another issue people get very scared about, and rightfully so. What's going to happen after I die? Well, I'm taking care of this person. I want to make sure that they're safe and taken care of and living the life they want to live. So these are ways to get to that in a very broad sense.
Speaking of getting to that,
some of you may have, we'll go on to the fiscal. So some of you may have already gone through the Social Security Administration. You can become a representative payee. That allows a person, the rep payee, we call it, to handle the Social Security checks, to handle it, put into a bank account, and expend the funds on behalf of the person. And obviously still has to benefit the person it's going to. You don't need guardianship for that. And in fact, guardianship can't determine who a representative payee is. That has to go through the Social Security Administration. Other fiscal ways of protecting people are through trusts, particularly if you think a person might be eligible for state or federal benefits. There are trusts that you can establish for people, which allows a pool of money to be used for their benefit without them having direct access to it. So it won't count as an asset or as income for the individual, and they'll be able to retain the benefits such as Medicaid. And then there are other things, just kind of common sense things, right? A money manager, you could hire an individual to just assist somebody with handling their finances, monthly bills and investments. A lot of people do it with their retirement accounts. You hire somebody that kind of handles your retirement account. So it could be the same there. Some of the other alternative, for fiscal that just makes sense for a lot of people is everything's done electronically now. Online banking. You can see when the deposit goes in. You can see when bills come out. You can get a text alert. Say if you're concerned with somebody being scammed for some reason, if it's going to be over a certain amount of money, you can get a text alert that, oh, my child's bank account just requested to send $200 to somebody. Just as a kind of funny aside, I also had a case once where the judge was asking the client, I was defending against the guardianship, and kept asking the client, well, how do you write checks? Do you write checks? And he kept saying, no, I don't write checks. And the judge was dumbfounded that somebody didn't write checks and didn't know how to write checks. It was because he did everything electronically. And the judge didn't understand that, the world had kind of moved on. We don't send faxes like we used to, and we don't necessarily write checks. There are other ways to do that. So online and electronic banking is another way that you can kind of keep an eye on things for somebody. Joint accounts, again, great way to make sure that something is either required to signatures or that you're at least notified when something happens. Bank cards with a limited amount per month, especially ABLE accounts. ABLE accounts will allow you to do this if somebody wants to save money. They'll take money from an investment side and put it into a checking account side, say $50 or $100 a month. That person now can use that card, but the most they can spend is that $100. So, if they take off to Foxwoods and start spending money, at least the damage is limited and maybe they're having a good time. There are opt-out programs for credit cards as well.
So just in terms of medical, as we've gone over before, you can do a simple release of information to the medical institution or to the medical provider to just be able to have that provider share information with you. You can also use a statutory healthcare power of attorney form, which is available to any of us, and probably all of us should have one anyway, which appoints someone to make decisions for you when a healthcare provider determines that you are no longer able to give permission. So it only springs into effect when somebody thinks that you no longer are capable of making a decision. And then, as always, we can have a living will, which can be a separate document or part of your healthcare power of attorney that gives specific end-of-life care instructions. I'll just quickly walk through these, but it's worth knowing that if your adult child is going to be in the adult system, either through behavioral health or developmental disabilities, there are supports available that will really enable someone to live safely and also support their decision making and things like money management in a very informal way. But that may be all that somebody needs is regular check-ins and help in organizing their independence. So we wanted to spend some time talking about supported decision-making, which is a new alternative to guardianship and became law last summer. We're very excited about it. It's used in multiple other countries and in several different states and now Rhode Island. And it helps to implement Article 12 of the United Nations Convention on the Rights of Persons with Disabilities that said people with disabilities are supposed to enjoy the same legal capacity as everyone else. And so it gets back to that capacity issue that we talked about earlier. What does that mean? And I think what the UN Convention is really trying to say is we need to make sure that governments are accommodating people with disabilities so they get to exercise the same legal and civil rights that the rest of us do with whatever support and accommodations they need. So there are some principles embedded in the supported decision-making statute. Some of the more important ones is that all adults should be able to choose to live where they wish and with whom they wish, and to accept or refuse support, assistance, or protection. And they should be able to participate in, they should be able to be informed about their affairs and participate in the management of their affairs. And their values, belief, wishes, and norms should be respected as others support them in managing their affairs. So how does it work? An adult with a disability chooses a person or a team of persons to be supporters, and the supporters help the person do one of three basic things. They help them gather information, they help them review their options for a decision, weigh the risks and benefits, see if they have all the information they need to make a decision, and then the supporter can help communicate the decision that the person makes. And in Rhode Island, the kinds of decision that a supporter can help with are healthcare, education, and living arrangements, but currently not financial decisions. Doesn't mean that the supporter couldn't offer advice, but they aren't legally able to be a supporter for financial decisions. The statute also requires that people create a supported decision-making agreement to outline what roles the supporter has, and to be clear that the supporter is helping to effectuate decisions, but is not making the decisions themselves for the individual. There's a specific form for a supported decision-making agreement that is part of the statute. You're not required to use that form. If you do use that form, however, you'll be deemed to be in compliance with the statute. So there's a few other caveats around the statute. Supporters can't be an employer or an employee of the adult with a disability, and they can't be a person providing paid support services to the adult, unless you are an immediate family member. Then you would be allowed to do that even if you're an employee or providing paid support services. And the form is self-executing, so it can either be signed in front of 2 adult witnesses or in front of a notary public. So why do we like supported decision-making? It helps individuals make decisions rather than having someone else make the decisions for them. It promotes independence, choice, and self-determination. And I think just a little more on that, there is certainly research out there that talks about the importance of self-determination and quality of life, and that generally the more we can support individual self-determination, the better their quality of life. Also, the experience itself of making your own decisions helps all of us learn. That's how we all learn. We learn from our past experience. So enabling people to make their own decisions and to keep doing that has not just civil rights implications, but significant growth and quality of life consequences for people. So here's some websites where you could go to learn more about supported decision-making. And I think hopefully our websites have some information on supported decision-making on them. So you can check the DD Council's website and our website at drri.org. And I guess we do have some time for some additional questions.
Should we just kind of start at the top of the question list and go down, or do you want to?
We've got quite a few of the same question, and the one that I think we have the most is, are there, you know, for all of these, whether it's guardianship, full-on guardianship, or any of these other processes, it sounds like there are costs, legal costs involved, and folks are asking, are there any resources or any supports, help with legal fees that are available for folks who need it?
There are a couple. Again, I mentioned the Bar Association. Someone said, other than the Bar Association, is there anybody else? Rhode Island Legal Services potentially could help as well. I don't, Anne mentioned that Disability Rights Rhode Island, I think, has been kind of only taking very specific cases. So I'm not sure that they would be open to just taking anybody who walked in. Who else? There was another, there's another group that could help too, and I'm drawing a blank, legal.
I'm not sure, but I think through volunteer lawyers, if someone qualifies for them, you could potentially, and many wards will, because many won't have, especially transition age people, won't have acquired a lot of resources yet in life. So they might qualify for free legal assistance through the Bar Association, the volunteer lawyer program of the bar. And I think that we've done work with them and training with them about alternatives to guardianship. So hopefully they will be knowledgeable both about guardianship, but also about alternatives. And in addition to the civil rights issues that we've talked about and just sort of promoting self-decision making and quality of life, the other thing about most alternatives is that they're free. I mean, you certainly can consult a lawyer, and probably should if you have significant financial issues that you're trying to deal with. But some of the other things you really do not need a lawyer for. And so the healthcare power of attorney, we can all execute those on our own. The form will tell you you can consult with an attorney if you want, but it's meant to be a tool that people use on their own. And some of the other less restrictive alternatives are really things that are just available to all of us every day. So those are no cost, low cost alternatives that are self-executing. You don't necessarily need, you don't need an attorney to do them. Obviously, if you have questions, you can consult an attorney. So they are, that's the other advantage. They're mostly less costly than guardianship.
And as Anne pointed out already, a lot of these, everybody should have in place already, particularly a healthcare power of attorney and a living will. I mean, those are two things every adult should have. And particularly young adults who say maybe off to college, disability or not, you're going to want to, and they're almost certainly going to want their parents to still be informed if there's a major healthcare decision that needs to be made, and they're still going to want their parents to be aware and to be able to help them make those decisions. So disability or not, it's a good idea for every adult to have a healthcare power of attorney and a living will, and potentially those HIPAA waivers that allows, you know, medical staff to communicate with parents.
So specifically around supported decision making, and you might have just answered this. Someone asked, is there a fee associated with supported decision making?
No, it really is self-executing, and you can find the form in the statute itself. You can just copy it, make a Word document out of it, and fill in the blanks. So it is pretty self-executing. I think both the DD Council and our office have some materials available on that, and we hopefully will be developing more, so that people will have some comfort level in filling out that form. But on its face, it's pretty simple. So filling out the form is not the hard part. It's the discussions that happen before and afterwards that need some thought.
And in talking about different resources that are available, one questioner asks if that information, those resources are available in Spanish, or are they available in other languages?
That's a great question, and I don't think we have the answer to that. But I do know one of our sister organizations has been able to translate things into at least Spanish. So I'm going to put this as a job for me to do. I will go and see if it's not available in Spanish, if we can get it available in Spanish as soon as possible.
And I'll just add to, and another questioner asked specifically about RIPIN, and does RIPIN have accessible services and reps to help people process these forms? And what RIPIN, what we have is a peer-led workforce. So 3/4 of the staff at RIPIN are peers, meaning they personally have someone in their life, a child or another loved one who has a disability or who has needed assistance with these kinds of processes. So we have people on staff who have lived this, and we're able to offer support, not in any kind of formal legal way, but definitely support to help people navigate the processes, because they can get quite complicated. And we have available our services in multiple languages, in addition to having people on staff in-house who speak both Spanish and Portuguese. We have access to a translation service that basically, if you call us, we can get somebody on the phone that speaks your language. They speak like almost 100 different languages, and we can have somebody on the phone to translate within minutes. So that is one resource that I know about that's available. Some of the other questions we have. So this one person asks, if the person already has supportive people in their lives, what is the benefit of supported decision making? What's the benefit of going through that process if they already sort of have that informal structure?
So it's great that they have the informal structure, and they hopefully will continue to have that. What this document does and what the official agreement does is make it legally binding. So you can take that to, say, a healthcare provider and give that to them, and then they will recognize that. Otherwise, if you just go to a healthcare provider and say, oh, no, they trust me to get the information for them, please give it to me. You know, a hospital won't give you that information unless you have the authority to do it, either through a power of attorney or through the supported decision-making agreement.
Right. And the same is true of schools or landlords or those kinds of things that people will have to accept. For instance, if somebody needs help communicating their desires, they would have to accept that the communication comes through the supporter for someone who needs help with communication.
So talking about healthcare power of attorney, does healthcare power of attorney also allow access to medical records, or the individual needs to complete an ROI in addition to naming a healthcare PA?
So a healthcare power of attorney springs into effect when somebody determines that the individual isn't capable of making healthcare decisions. So at that point, the person who is appointed as the agent of the individual can collect medical records. For instance, I have a healthcare power of attorney, but my agent right now can't collect. Hopefully nobody thinks I'm in lack capacity, but can't collect records about me. But certainly if I became ill or was unable to communicate my decisions, they would be able to do that. And I just wanted to make one note about healthcare powers of attorney and supported decision-making. They're not mutually exclusive. We recommend that people do both things, because in order for supported decision-making to work, the individual needs to be able to communicate their decisions. And so everybody probably needs the backup of a healthcare power of attorney anyway. I mean, you could become unconscious through illness or an accident and not be able to communicate your desires. So even if you have a supported decision-making agreement, your supporters may not know exactly what you want to do and be able to effectuate your decision. So it's always good to have a healthcare power of attorney as backup, so that a provider knows who's the person that you want to make decisions if you can no longer do that because you're ill or have.
And to go back to the person's question, so yeah, you should definitely have a healthcare power of attorney, but you might also want that HIPAA waiver, or a waiver so the medical people can release information. I think that's what they're looking for. Yes, that document exists, and yes, you should do that as well.
Yeah.
So lots of questions, and trying to get to as many as we can. Several questions pertaining to this is my situation and what's kind of the best move. One person asks, what about a nonverbal and severely affected child with autism? Another person asks, my son will be 18 in December. He has high functioning autism. He's in the 12th grade, and we're not sure which way to go on guardianship. They like to watch over things like medical and financial. It sounds like you talked about a lot of the different options today, but for folks who are kind of trying to come to that decision, based on their own family circumstances, is there anything you can recommend?
So they're kind of two very different,
very different scenarios for sure.
But so on the person who can clearly make their own decisions, I don't know a court would give you guardianship anyway. As a parent, we all want to still control our kids for safety reasons as long as we can, right? We care about them, so obviously we don't want to make bad decisions, but making bad decisions is kind of part of life, and it's part of growing up, and it's, we wouldn't demand anyone else make our decisions for us. So it's something that you can't expect to be able to make decisions for your soon-to-be adult child. For the other person, I don't know. It really depends on the situation. Just because someone is nonverbal does not mean that they don't understand, for instance, that they want their mom to go with them to the doctor. If they can express that somehow, then that's making a decision. And again, when we got to what's the capacity required to make certain decisions, for the healthcare power of attorney, it might just be indicating, yes, this is the person in my life that I would want with me to hospital, or that I would want to make decisions if I can. And that might be good enough. So it really is going to depend on the individual case there. But just because someone's nonverbal certainly does not mean that they can't communicate those kind of things.
And similarly, looking at supported decision-making, one of the reasons we really like it is because it gets rid of the concept of capacity. We should not need to assess someone's capacity in order for them to use supported decision-making. So obviously the supporters have to feel comfortable that they have a way of communicating with the person and understand what they want. But the question of capacity is not part of the analysis of whether someone can or should have a supported decision-making agreement. Obviously, some level of communication is necessary in order for the person to be able to communicate to their supporters their desires, but there isn't the same legal analysis of capacity that you would certainly find in a guardianship proceeding.
When it comes to supported decision-making, can an individual living in residential housing have the agency be part of it? Can they be part of that process?
Not currently, no. The law would prohibit that. They'd be a paid provider of services. Although, just on that note, lots of people have past providers in their lives, either people they have met through school or other providers who they maintain relationships with. So there would be nothing wrong with using a former provider of service as a supporter if that person is still involved with them and in their life and they want to use that person. Lots of people may still have that, though those relationships may still exist.
Another question we're getting a lot of different sort of variations on is, at what age should we start the process, whether it's guardianship or whatever it might be? Your child's about to turn 18, turning 18. At what point, at what age should you start looking at all this?
So ideally, as soon as the child, at 2 years old or maybe even younger, right? We want to involve children in and allow them to make appropriate decisions for themselves. Right? I'm more likely to let my 12-year-old child decide what to have for lunch than my 5-year-old, because the 5-year-old's going to choose candy. So, but even in a more formal setting, for instance, if you've got a child, say in elementary school or particularly in high school, you should be kind of transitioning over to allowing them to run the IEP meeting, or at least to participate significantly more. One recommendation that I'd have is, instead of it just being a family just a parent and child going to an IEP meeting, bring a friend, bring one of the child's friends with you to an IEP meeting if they have one. And it allows them to start building the necessary skills to make decisions later in life. As far as when should we start the guardianship process, you can't start it before 18 anyway. So the more you can build the person's capacity prior to that, the better. But even after 18, there's still plenty of opportunity. Like I said about having a bank card with, say, just a limited amount of money, $20 or $50 a month or something like that, where they have control over that. It will, help teach them how to utilize money, or that if you just spend it all instantly on one thing, then that's it till the next month. Just little lessons like that can be really helpful.
Right. Yeah, no. I think that's key, is building self-determination skills throughout the child's lifespan, right? So that they can start making more complex decisions as they age. Also, the school transition process provides a unique opportunity, to start exploring some of these issues about adulthood. Who's going to be available to me to help support making my decisions in the way sort of that the IEP team is supposed to be fulfilling that role. So it really hopefully comes up from, at least in there are more formal discussions, hopefully by the time a child turns 14, about those kinds of long-term decisions, about how I'm going to make decisions, who's my support network to help me do that, and what are my options that are available to help me make decisions. We think that's a really important transition topic.
One question, are there ever times when you recommend guardianship?
Very rarely. There certainly are people, sadly, who have no one in their life who they can appoint, either as an agent under the powers of attorney, or who can help them in less informal ways, or who is available to be a supporter. And so in some times there is no alternative but to rely on a court-appointed guardian. And I think the vast majority of people can make their wishes known, as we talked about, but there certainly may be individuals for whom no one has figured that out yet for them and with them.
So a few questions about the sort of determination of guardianship. You mentioned early on that you need a DMAT, and you talk about a medical professional having to do that. This person asks, they say their son's primary care physician is not an MD, but a nurse practitioner. Can that, but the form has to be completed by an MD, or the assessment has to be completed by an MD. Is there a way around that, or any solution to that?
I would have to go back and look at the statute. I think it's been changed several times to try to come to grips with this, but I believe it says treating physician. But perhaps the nurse practitioner works in a practice with other people. So.
And that's not to say that, because I saw other questions, can somebody else provide a DMAT? Absolutely. Just because one of them might have to be by the physician, a physician, doesn't mean that nurse practitioner still shouldn't send in one, or somebody asks about DCYF or ASA or whoever else. If there's anybody with knowledge of the person, they can also submit a DMAT. It doesn't even have to be professional, frankly, although the court may weigh things differently, but anybody can submit that DMAT.
Yes, and it's helpful, I think, particularly in opposing guardianship, to have different views presented, and people who are apt to know someone better than a primary care doc who may see someone once a year if they're healthy. So, and knows them on a very different level than people who see them day to day. Just in a contested matter, I think the courts generally are going to give deference to medical doctors. That's just the legal world and the legal world of experts right now.
Somebody asked, do you need DMAT for supported decision making? It sounds like no. That's one of the sort of benefits of it. It's a much more streamlined process. Another person asks, do the HIPAA waivers, do they need to be signed by every single physician?
So they wouldn't be signed by a physician. They'd be signed by the individual that's giving permission to share their health information. Then you would provide it to, say, your primary care physician or whatever physician or hospital that you'd want that information from. I will say you might develop your own and go to a hospital and say, here's my HIPAA waiver. And they might say, our legal staff wrote one up, have them sign this one instead. So they might want their own signed rather than the one that you did. But yeah, no, it's just signed by the person that's giving the authority to somebody else. So it's not signed by a doctor.
And then kind of similar, kind of along the same lines, someone says, if one has a living will, healthcare power of attorney, and supportive decision-making, where do they get stored or who do they get submitted to? Where do these things go?
So a healthcare power of attorney, depending on what, so the healthcare power of attorney should be given at least to the primary care physician, and then you should have a copy in case you need to give it to somebody else, right? Living will should be, you might want to put that on record with the primary care physician or hospital, but the person who's going to ultimately be making those decisions should also have a copy. Whoever the attorney is in the healthcare power of attorney, whoever's going to be making those decisions should have a copy so that when they go in, they can say, look, see, I have the authority to do this. What was the third? Decision making, same thing. It depends on what it's for. So if it's for housing, it should be a landlord or a service provider. If it's for health related, it should be a hospital or primary care physician that you give it to. So you sign it yourself or you develop it yourself with the supporters, and then you bring it to whoever you want to follow the orders.
We used to sometimes recommend that people execute a couple of copies of those documents, which people can still do. But in this world, electronic world, I think more and more, having electronic copies of these documents is probably a really good idea. And making them available electronically to people will probably work for most people. Healthcare might be a little pickier, but it will probably work.
What is the benefit to not using the supported decision-making form and making up your own form?
You can certainly do that. And the good thing about the statutory form is that if you use it, it should be recognized and people won't say, oh, you didn't follow the statute in this way. If you use the form, you'll have been deemed to be in compliance with the statute. So if people want to edit it, I would suggest using the form and adding to it rather than subtracting from it. And that should work well, hopefully, rather than writing your own. Our hope is that the form, like the healthcare power of attorney form, which is a statutory form, will become so widely recognized that people will look at it and say, oh, I know what this is, right? So the more you can be uniform, the more it helps you.
So it is just after 2 o'clock, and I don't know if you're able to hang out and answer some. We still have a few questions, and I don't know if you want to maybe Kevin, you're looking at the questions and see if there are any that jump out at you that you'd like to take next.
Let's see. So the one at the top of the list has to do, I have guardianship, what happens when I die? Again, it's a court that rules everything, so they would appoint the next guardian. But I will suggest you look to an organization such as Plan Rhode Island. What they do is build a community of support around a person so that they have the supports they need after the parents are gone, well, while they're alive, and it continues on after the parents have passed away. So that's one option for that person. Would a power of attorney be needed in addition to having guardianship? It depends on what you have guardianship in. If you have it in all 4 areas, probably not. But say you have it in healthcare, you might need a power of attorney for financial, but otherwise, no. So it's only if it's a limited guardianship and what you're looking to do is in another area.
I saw a question on there about how long a guardianship order lasts, and it lasts for the person's lifetime. So we talked a little bit at the beginning about it's possible to seek to remove a guardian or to modify a guardianship, but the burden at that point is much higher than the initial burden to get a guardianship in very practical terms. And so really, sometimes we're successful in removing a guardian if we can show that person's circumstances have changed, that they have improved in their decision-making ability. That's a difficult case to make. Not because it's not true, but it's just difficult to assemble evidence that somebody has decision-making ability has improved. And then in the other circumstance, which sometimes is a little more successful, is asking a court to find that there are other less restrictive alternatives out there, like the ones that we've talked about, that are going to work well to support the person. And so guardianship is no longer necessary. But that is something I think people need to be conscious of, that this is for life once that order is instituted, and undoing it is not guaranteed, and it is time consuming to try to do.
And there's a related question that someone asked, you know, as my son gets older and hopefully finds someone and marries, can guardianship or power of attorney be switched back to him? And it sounds like you're saying that that's a difficult process.
Yes, although I will say there is some old case law in Rhode Island that says a guardian can't prevent a person from marrying. I'm not sure if courts would honor that right now, thinking that marriage is a fundamental right, but it's an interesting question. And we have had cases where that precipitated a guardianship, where parents were very concerned that their son or daughter was marrying the wrong kind of person. And it's probably true that a lot of parents think that. But don't think about using guardianship as a way to prevent that.
That's a good point. And in addition to marriage kind of being a fundamental right, a lot of other issues that people think guardianship will help solve. I saw somebody had a question about taking psychiatric medication, and you can't use guardianship to have a person committed, correct, Anne?
That's correct. And truthfully, you shouldn't be able to consent to psychotropic medication without the person's consent. So if even if you're a guardian and if the person is pushing the medication away and saying, no, I don't want it, we would argue that that is a more fundamental right, because many of those medications have significant side effects, often worthwhile, but still taking the meds, but still have a significant impact on someone's health. But definitely, no, you can't commit someone in this state against their will, either as a developmental disability commitment or as a mental health commitment.
We can keep going with questions if you guys have time.
I'm okay with it, Anne. I don't.
Yeah, I have a few more minutes. Yep.
One of the other questions is, if a person does not have the ability to consent to power of attorney, how do you move forward with this option? So again, who's making the decision that they don't have the ability to consent? And as we talked about with the healthcare power of attorney, can they indicate that this person is who they'd want with them to go to a hospital, or this is the person, you know, my mom always comes with me to the hospital. That's who I would want to make decisions. That might be all that's required to get that kind of consent for that. So the levels of consent are a little different, and it's a pretty low barrier to giving that kind of consent. So beyond that, if a person's saying that that's what they want or communicating that that's what they want, nobody else except for a probate court has the right to say, no, you don't have the ability to consent.
Yeah, and they don't need they don't need to be able to understand what the treatment is, right? I mean, they just need to understand that they want this person to be making decisions with them and for them on the healthcare power of attorney.
Likewise, who determines if a person cannot make medical decisions? It's officially, legally, it's a judge. But in the real world, it could potentially be a doctor that says, I don't, I'm just a little nervous that you don't really understand this. And that's where the support decision-making agreement would really come in handy. Say, okay, we understand, and we'll take the information back and then explain in a way that they understand, and then we'll come to a decision. So there's a legal answer, and then there's a reality answer. And so sometimes it is a doctor that says, I'm just a little nervous, and I don't think that they fully understand this. Another question, what if an adult refuses to sign the HIPAA form or any of these forms? So again, what we're talking about is people have the right to make decisions, and one of those decisions is to not give somebody the authority to get information about them. So short answer is, if they refuse, then they refuse, and you can't get that information.
I saw a couple of questions on age of guardianship. For adults, you need to go to probate court. For anybody 18 and over. Family court certainly has authority to appoint guardians for children as well. But for adults, it's 18 and over is probate courts.
There's also a question here about how much money in the bank can a ward of the state have in their personal account. Is there a limit? Again, it depends on what kind of guardianship was given. Do you have financial guardianship, or do you not have financial guardianship? For most people that we're talking about, they're not sitting on loads of money. So really the fiscal piece isn't as much of a worry. And if people do have a lot of money, then we really recommend looking to deposit it in either an ABLE account or some sort of trust to protect it so the person still can receive benefits. And generally speaking, but you got to talk to a benefits counselor about this, it's around $2,000 of assets total before they would lose benefits. I hope that answers that question.
All right. One person asked, what about a person who's a danger to himself or others? That sounds like there's a lot of different things that might be going on, and like lots of different circumstances.
Sure. I mean, and there's a range of danger, right?
Right.
I mean, we talk about that, and certainly in life. I mean, what's an acceptable risk for any? I think mostly about transition age people, right? As people turn 18, it's like, and as parents, it's like, how much risk can you tolerate for someone? And there's the simple risk of, going somewhere that makes you nervous versus being exploited by someone else. So in terms of risk, the ultimate state intervention is commitment that we talked about before. And that is part of the burden of someone seeking commitment, is proving that someone is a danger to themselves or others in a very narrow set of circumstances. And that is a process that exists outside of guardianship. So if someone were truly a danger to themselves or others, either by reason of their mental illness or their developmental disability, there's a separate process for that. And it's an authority that the guardian signs anyway.
Should we go on?
So just, does the ward need to agree with the power of obtaining a power of attorney? So they're not a ward at that point. They're just a person. And yes, if they're going to assign someone power of attorney, it's their right to assign somebody, but it's their decision to do that. Hopefully that answers that. How do you apply for volunteer lawyers? And do you know
You can just call the Bar Association number, Rhode Island Bar Association. I don't want to give the number because I'll forget it, but you can just Google it, and they'll direct you to the volunteer lawyer program that's part of their office. I did see a question about the healthcare power of attorney, and I haven't checked to the last month or so, but there was the statutory form was on the Department of Health's website. So if you Google that, you should be able to find that site, and you can just download a copy and fill it out yourself. It's pretty easy, and it's great that it's available on the state's website.
A question, does the supported decision-making form have to be presented to the probate court? That's the beauty of the supported decision-making agreement, is it's a private agreement. Just something you sign. You're not involving the court at all. You're avoiding guardianship, and you're avoiding bringing the court into, you know, that personal relationship. So no, you certainly do not have to provide a supported decision-making agreement to the court. If somebody already has guardianship and you're looking to lessen it or wipe it out, then you might want to bring a supported decision-making agreement and say, hey, look, we found a less restrictive alternative. Maybe you can get rid of the guardianship now. So that might be helpful if you're looking to end the guardianship. Who are some resources to assist if someone needs assistance with developing a trust to preserve eligibility for benefits? So we also do some presentations on like able accounts and trusts and that kind of thing, but that's a whole nother hour. But certainly there are attorneys in Rhode Island. You're not allowed to say you specialize in something, but there are attorneys who focus on trusts and able accounts. And you know, I would find an attorney and make sure that this is one of the things that they do well, because for a trust to protect benefits, it has to be very specifically written. And so you want to make sure that the attorney has the knowledge to properly form those documents. They should certainly know about able accounts. I'm hoping, although not a lot of attorneys know about the supported decision-making agreements, but if you find an attorney that knows about all those and incorporates them, then you probably found a pretty good one. Otherwise, if you're already in the system or you're transitioning, there are benefits counselors. I know that the Sherlock Center could probably put you in touch with some benefits counselors, and they can walk you through how much money can I have, what kind of trust would I need, if I come into some money all of a sudden, how do I protect it, that kind of thing. How long should I work? How many hours can I work? How much money can I make? All that stuff will go through a benefits counselor.
Okay. Well, I don't know if you have any further answers or if there are any more. You've already, I will say, we've been doing webinars now at RIPIN for about 8 weeks, and this one has generated by far the most questions that you folks were able to answer. So thank you for sticking around to answer them.
We kind of answered it earlier, but for the teacher, you know, again, I'm hoping that they can talk to the family and talk to the individual and kind of maybe put a halt to that, because it sounds like they definitely don't need the guardianship. But if it does ever, and Anna answered that before, but if it does ever ramp up, then she should certainly be maybe filing her own DMAT with the court if necessary.
Great. Well, I want to thank everybody for joining us today. I want to thank Anne and Kevin for giving a great presentation. And like I said earlier, you can call RIPIN for more information, for more assistance with these issues. And after the webinar, we're going to send you, everyone who attended, an email with links to more resources, a recording of the webinar, and places where you can find more help. But thank you again, Anne and Kevin, and I want to thank you all for joining us. Yeah, until next time, this is Mark on behalf of RIPIN signing off. Take it easy.
Thanks.
Thank
Bye.
you all. Yep. Bye-bye.